What's up, Josh Halpern here. We are back for another video on foreign legal considerations. Now you're all settled domestically. You know your new market is free of export restrictions. You made sure you and your partners have the right insurance coverage. And you're not trying to bribe anyone or engage in monopolistic activities. Pretty cool. What's next? Next step is to protect yourself and your product once they leave your country of origin. In this video, we're going to talk about what an international contract is before jumping into the heart of intellectual property rights. But first off, here's a quick word on the basic legal structures of governments around the world. Selling overseas is a lot easier when you understand the basic legal systems of the country you are exporting to. Knowing the groundwork for legal fees, documentations, customs, intellectual property, and contractual obligations will help you make more informed decisions. And one of the first things you need to know is under what legal system is a country operating. These are the three basic forms of legal structures in the world today. 1. Common law. 2. Civil law. And 3. Theocratic law. Common law is the system we have in the US, but also in the UK and most of the UK's old colonies. This system relies mostly on tradition, precedent, and custom. The courts are responsible for interpreting the law based on these characteristics, and that's why we often see a court overturn a law that is considered unconstitutional. Contrary to civil law, in common law systems, laws are constantly revised by government agencies and officials. Civil law, on the other hand, is a legal system that relies on a detailed set of laws organized into codes, often referred to as codified law for that reason. It's a system used in many countries, including Russia, Japan, and many countries in Europe. Courts in a civil law system are not often asked to interpret the law, since laws are often codified and have been developed with greater consensus and precision than under a common law system. Now, the last system is a theocratic one, which is a legal structure based on religious precepts. We see these systems in place in Saudi Arabia and Iran. Now, why does this matter to you exporters? It does because it will change how you legally do business. This is especially true when drawing up a contract. In common law systems, as you may be familiar with, contracts are usually a lot longer and complex than in civil law, because they need to include various contingencies not specifically covered in the law itself. In a civil law contract, many of the issues for an exporter are already covered in the laws themselves, and they don't need to be repeated. Now, you may have heard your overseas partners complain that our contracts are too long. They may even be fearful of signing it because it is super intimidating. So you may want to prep them before shooting off an email with a new contract, or worse, having your lawyers shoot off that email. Now, once you know the system you're dealing with, you can better choose the lawyers that help you make the contracts compliant. Now, once you've determined the market you're going into and the legal system at which it operates, you can choose the right lawyer to help you make sure your contracts are compliant, including your privacy policy, your terms, and your conditions. Now, international contracts. Once you've found a great legal partner, you can sit down with them and build the international contracts that will be compliant both in your country of origin and the country where you wish to export. We won't get too deep into international contract law because you shouldn't be doing this alone anyway. You should be consulting a lawyer. So get expert assistance from somebody who knows the legal system and the ecosystem of the country you are exporting to. For example, exclusivity of representation is one of those things that you really need an expert to understand because it's almost entirely regulated by contracts in local laws. For example, you really need an expert who understands the laws in the country you're going into because there are certain nuances, for example, exclusivity of representation that is almost entirely regulated by local law. And all these specific aspects must be addressed in your contract. So, there you have it. The three types of legal structures in the world. Go forth and sue people. No, ideally if you do this right, you won't have to, and you'll avoid a lot of issues down the road. Now let's jump into the core of this video, intellectual property laws. We wanted to talk to you about intellectual property laws because they are extremely important for all exporters. They are also somewhat complicated, so it's best left to an appropriate legal expert, but I'm not one, I live in a van. Let's just talk about it in layman terms and get the basic awareness covered. So, we wanted to touch base. There are three differences between patents, trademarks, and copyrights. Patents. The US patent law system is quite different from what you'll see in other countries. That means that many protections you might take for granted in the United States might not apply when you're exporting, because intellectual property is enforced and understood differently from one country to the other. But first, what is a patent? A patent is a government authority or license conferring a right or title for a set period for the sole right to exclude others from making, using, or selling an invention. In other words, it's to prevent someone from stealing your idea, producing it, and making money off of something that you've created. If you followed the proper steps, you should already have your patent in the US or be in the process of acquiring it. And once you know which country or regional authority you want to start exporting to, you need to apply in the region or country as well. Now, you may have to appoint a foreign agent to do so, as many countries do require that the application process go through a local agent or a law firm. I know, they're going to get you somehow. Some regions will make it easier by requiring that you apply only once for the whole region, as is the case with the European Union. One note from the field, in my experience, patents are not just to protect you in countries where you want to sell to, but also where you're manufacturing in. One of my clients has a patent for his product in the US, but did not patent his product in China, and his manufacturer did. So now he cannot manufacture in China, even if the manufacturer can't sell into the US. It's a problem for both parties, but he was there first. Trademarks. Enough about patents. Let's talk about trademarks. A trademark is a word, a symbol, a slogan, a name, or any combination of those that identifies your business or your brand and distinguishes the source of a product as coming from you and only you. Trademarks apply to products and service providers in the same fashion, and you should always take steps to protect them, even if you're only selling in the US. And if you have an inkling that you're going to be selling someday down the road. I've got companies who weren't in China, for example, for 10 years. They finally went in and they found out that their logo and their name was already taken. As with patents, there is no international protection of your trademark. You must apply for a trademark in all the countries or regions to which you plan to export. Registering a trademark gives you exclusive rights to use specific images, languages, words, names, logos, and designs in connection with your products and services. Now, there are two principles used in the world to recognize a trademark. First use principle. According to the first use trademark principle, the first entity to use the trademark in connection with a product or service is the owner of said trademark, even if they are not the first to register it. A trademark registration is only there to enhance this right. Now, the other option is the first to file principle. In countries like China that have adopted a first to file principle, the owner of a trademark is the first who registers it. This unfortunately has led to people stealing other people's trademarks. However, most of the time, trademark holders do have a period in which they can file for international trademark protection. Trademark owners do have a period in which they can file for international trademark protection, which means that you have to be proactive in your planning. And yes, even if you're going to a country that you think does not offer real protection when it comes down to it, having the piece of paper saying you tried is the first step, and without it, there's absolutely no way you're going to protect yourself. The good news is that thanks to the Madrid Protocol system, trademark holders can apply for foreign trademark protection through the U.S. Patent and Trademark Office. As for any legal concern, your best bet is always to consult a lawyer, not me. Before you can register your trademark, they will confirm that you're not infringing on someone else's trademark. You can do this research yourself, as I often do on uspto.gov, but use it as a first step, not your final process, because you do want to consult a lawyer just to make sure the nuances are covered, and they have a lot more experience than any of us. Copyrights. Now, our last intellectual property friend is copyrights. Copyrights refer to your authorship of original works, be they literary, musical, architectural, artistic, and more. Copyrights are usually easier than patents or trademarks to obtain. Most countries will only require that you show where your material was first published in order to determine its eligibility for local copyright protection. Here again, working with an expert should be your go-to decision. So, to sum it up, patents are to make sure nobody is stealing your idea. Trademarks is to make sure nobody's using your brand, and copyrights will help you guarantee your artistic, architectural, literary, and other works cannot be copied. You need to apply for all these in the country that you are located in, for example, the US, but also in the country where you're exporting to and possibly manufacturing in. And trademarks is the only protection you can actually apply for internationally through a US agency. And there you are, all protected and ready to propel yourself onto the international stage, but not so fast. The structure of your company is now compliant with domestic and international laws. But what about how you do business, your marketing, your labeling, and all of that? In the next video, we'll look at different legal aspects of your selling strategy to make sure you're legally ready to jump in and conquer a new market. So let's recap. We covered the three main types of laws around the world: common law, civil law, and theocratic law. We've covered protection of your brand through intellectual property rights, which protect you from having your ideas, inventions, brands, markings, and artistic works stolen. The three types of these are patents, which correspond with physical aspects of your product, such as an invention or product. Trademark. This is a specific creative asset that identifies your product. And copyrights refers to the authorship of a body of work. Now, there's lots of government and industry resources. We put a few links here so you can find what is offered for free and what lawyers will likely and happily charge you money for. Let's check it out, and we'll see you in the next video on the legal aspects of cross-border trade. Ciao.